Introduction. The law relating to contract is governed by the Indian Contract Act 1872. It came into force from 1st September 1872. It extends to the whole of India. Originally, the Act contains 266 sections, Section 1 to 75, including Section 19A, 19B, and 19C, which deal with general principles, are prescribed for study in the present subject contract 1. The remaining section, that is from section 76 to section 123, which dealt with sale of goods, is repealed and replaced by the Sale of Goods Act 1930. Section 124 to 238 deal with certain specific contracts, that is, the contracts of indemnity and guarantee. That is subsection 124 to 147. Contracts of bailment and pledge, subsection 148 to 181. The contract of agency, subsection 182 to 238, and section 239 to 266, repealed by section 73, and schedule 2 of the Indian Partnership Act 1932, are studied in the other subject contract 2 or special contracts. Contract meaning, definition. Meaning: the term contract is derived from the Latin word contractum, which means drawn together. It is an agreement entered into between two or more persons or parties, subject to certain terms and conditions for a lawful consideration. Example: A and B enters into an agreement. A promises B to sell his house for rupees 50,000 and B accepts to purchase it for the said amount. It is a contract between A and B. In a contract, there are two parties, namely the promiser or offerer, that is A in the above example. The other party is promisee or acceptor, that is B in the above example. In the above example, A and B entered into an agreement. The agreement is enforceable and hence it is a contract. Enforceability means if one party in the contract fails to perform his contractual obligation, the other party can file a suit against him for fulfillment of the obligation. In the above example, if A fails to sell the house, it amounts to breach of contract and B can approach the court. Similarly, A can approach the court if B fails to purchase the house. In certain contracts, like a contract of guarantee, there are three parties, namely 1. Principal debtor, 2. Creditor, and 3. Guarantor or surety. Definition of contract, Section 2H and Section 10. Section 2H of the Indian Contract Act 1872 defines a contract as an agreement enforceable by law. Thus, for the formation of a contract, there must be 1. An agreement, and 2. The agreement should be enforceable by law. Agreement is equal to offer plus acceptance. Contract is equal to agreement plus enforceability. The conditions of enforceability are lawful consideration under Section 2D and Section 25, competence of parties under Section 11 and 12, free consent under Section 13 to 22, and lawful object under Section 23 to 30. Now the question is, what is an agreement? Agreement, Section 2E of the Act defines agreement as every promise and every set of promises forming the consideration for each other is an agreement. To constitute an agreement, 1. There must be at least two parties. 2. There must be a proposal or offer from one person or party. 3. There must be an acceptance from the other person or party. In the above example, A offered to sell his house and B accepted to purchase the same. A is called offerer and B is acceptor. Proposal or offer becomes promise when it is accepted. Section 10. According to Section 10 of the Indian Contract Act 1872, all agreements are contracts if they are made by the free consent of the parties competent to contract for a lawful consideration and with a lawful object and not hereby expressly declared to be void. In other words, when two or more competent parties, Section 11 and 12 freely consented, Section 13 to 22, to enter into an agreement not declared void with a lawful object, Section 23 to 30. For a lawful consideration, Section 2D and Section 25. The contract is said to be valid contract under Section 10 of the Indian Contract Act 1872. Distinction between contract and agreement. Contract, it emerges from an agreement. Section 2H, Section 2H and 10 define contract. Third, every contract is an agreement. Fourth, it is always legal and enforceable. Now, agreement. It emerges from consent of parties. Second, Section 2E defines an agreement. Third, every agreement is not a contract. Fourth, it may be moral and may not be enforceable. Now, essentials of contract, Section 10. As stated above, contract is something more than an agreement. Therefore, it is said that all contracts are agreements, but all agreements are not contracts. To constitute a contract, the following conditions are to be satisfied. 1. Two parties, offerer Section 2A and acceptor Section 2B. Second, consensus ad idem, that is identity of minds. Third, capacity to contract Section 11. Fourth, pre-consent Section 14. Fifth, lawful consideration Section 2D. Sixth, legal relationship. Seventh, lawful object Section 23. Seventh, terms must be certain. And 9, possibility of performance. Explanation for the first, that is two parties, offer Section 2A and acceptor Section 2B. To constitute a contract, there must be an offer and acceptance. The person who offers or makes offer is called offerer, and the person or party and the other party or person who accepts the offer is called acceptor. Therefore, in every contract, there must be at least two parties, namely the offerer and acceptor. The offer and acceptance must be communicated properly to each other. Second, consensus ad idem, that is identity of minds. A contract to be valid, there must exist consensus ad idem. It means identity of minds between the parties to the contract. In other words, both the parties to the contract must have agreed or consented about the subject in the same sense and at the same time. In the absence of consensus between or among the parties, the contract is declared null and void. Example, A has two houses, namely X and Y. A offers to sell X to B. B accepts thinking that it is house name Y. Here there is no identity of minds and hence it is not enforceable. Third, capacity to contract, Section 11. The parties to the contract must be competent to enter into a contract. According to Section 11 of the Indian Contract Act, any person is competent to contract provided 1. He is major, not a minor. Second, he is of sound mind, not of unsound mind. Third, he is not disqualified by law in force to contract. According to Section 3 of the Indian Majority Act 1875, a minor is a person who has not completed the age of 18 years. The age of minority extends to 21 years if a guardian of a minor's person or property is appointed under the Guardians and Wards Act 1890. In England, a person below the age of 21 years was a minor till 1969. With the passing of the Family Reforms Act 1969, the age limit was reduced from 21 to 18. Now in England, also a person below the age of 18 years is a minor. A contract entered into with a minor is void ab initio, that is invalid at the very beginning, as laid down in the leading case of Mohuri Bibi versus Dharamdas Ghose. Fourth, free consent. Section 14. According to Section 13 of the Indian Contract Act, two or more parties are said to consent when they agree upon the same thing in the same sense and at the same time. Consent is said to be free when it is not caused by flaws in consent, that is, coercion or undue influence, or fraud, or misrepresentation or mistake. Section 14 of the Act defines free consent as consent is said to be free when it is not caused by 1. Coercion as defined in Section 15, or second, undue influence as defined in Section 16, or third, fraud as defined in Section 17, or fourth, misrepresentation as defined in Section 18, or fifth, mistake subject to the provision of subsection 20, 21 and 22. Fifth, lawful consideration. Section 2D. Consideration is one of the most essential elements for formation of a contract. It means something in return. It is a price for the contract. It refers to both the parties. A contract to be valid and enforceable, there must be a lawful consideration. Example, A sells his house to B for rupees 10 lakhs. Here, A's lawful consideration is rupees 10 lakhs. Similarly, B's lawful consideration is the house. Therefore, it is said that a contract without consideration is void. In other words, a contract without consideration is not valid and enforceable. Therefore, it has been contained or enshrined in the Latin maxim that ex nudo pacto nor oritur actio, which means out of a nude fact no cause of action arises. In other words, a contract without consideration is void. However, there is an exception to the general rule under Section 25 of the Indian Contract Act 1872 as stated below. 1. Love and affection, Section 25(1). Second, compensation for voluntary services, Section 25(2). And third, time barred date, Section 25(3). Consideration may be past. Example, A paid rupees 10,000 to B to perform a lawful work. Present, A pays rupees 10,000 to B to perform a lawful work. Or future, A promises B to pay rupees 10,000 to perform a lawful work in India. But in England, present or future consideration is valid and past consideration is not valid. In other words, past consideration is no consideration. So explanation for the sixth point, that is legal relationship. A contract to be enforceable, it must create a legal relationship among the parties. Mere domestic or social agreement do not give rise to create legal relationship or consequences. For instance, a lawful wedded wife is entitled to enforce her claim of maintenance by filing a suit against her husband. However, she cannot sue her husband for pocket money or other things outside the legal necessity. Example, costly jewelry, car, etc. The relevant leading case on this point is Balfour versus Balfour, 1919. The defendant in the instant case was a civil servant in Ceylon. When he left for England, he promised his wife, plaintiff, to send 30 pounds per month, but he did not send the amount. The plaintiff filed a suit against her husband. It was held that the suit is not actionable or maintainable on the ground that it does not give rise to legal consequences. Another leading case on this point is Harvey versus Passy. The defendant were the owner of the plot of land known as Bumper Hall Pen, the plaintiff being interested in purchasing the same. Sent a telegram to the defendants, "Will you sell the Bumper Hall Pen?" Telegraphed lowest cash price. The defendant in reply telegraphed lowest price of Bumper Hall Pen £900. The plaintiff sent another telegram to the defendant saying, "We agree to buy Bumper Hall Pen for £900 asked by you. Please send us your little deeds." The plaintiffs contended that the second telegram from the defendants quoting lowest price was an offer, and the same had been accepted by the plaintiffs, and the contract was complete. The defendants, on the other hand, contended that quoting the price was not an offer which could be accepted. The Judicial Committee of the Privy Council held that exchange of the above stated telegram had not resulted in a contract. It was observed that the first telegram had asked two questions, one regarding willingness to sell and the other regarding the lowest price. In reply, only the lowest price was quoted, and this quoting of the price was not an offer. The third telegram from the plaintiff saying, "We agree to buy," was only an offer and not the acceptance of the offer. Since this offer has not been accepted, there was no binding contract between the parties. Number 7, lawful object and legality of object, section 23. A contract to be valid, the object for which it has been entered, it must be lawful. According to section 23 of the Indian Contract Act 1872, an agreement entered into with lawful consideration or object is declared void if it is 1. Forbidden by law, or 2. defeats any provision of law, or 3. fraudulent, or 4. causing injury to person or property or another, or 5th. immoral or opposed to public policy. An agreement entered into against the interest of general public is deemed to be opposed to public policy. In other words, an agreement which is harmful to public welfare is said to be opposed to public policy. Such agreements are: 1. Agreement in restraint of trade, section 27. 2. Agreement in restraint of marriage, section 26. 3. Agreement in restraint of legal proceeding, section 28. 4th. Wagering agreement, section 30. 5. Agreement to commit a crime. 6. Agreement with alien. Point number 8. Terms must be certain, not vague. The terms and conditions of the contract shall be clearly furnished in the agreement without any ambiguity or vagueness. In other words, the terms of the contract must be clear and certain, otherwise the contract is not valid and enforceable. Example: A offers B to supply 100 tons of oil. In the above example, the terms of offer are not clear, since the nature of oil, whether coconut oil or groundnut oil, etc., is not mentioned. Relevant leading case on this point is Taylor versus Portington, 1855. The plaintiff in the instant case A promised to take defendant B's house on lease for period of 3 years, provided it is thoroughly repaired and the drawing rooms are decorated according to present style. It was held to be not enforceable, since the terms are too vague and uncertain. Point number 9, possibility of performance. One of the essential element of contract is possibility of performance. If the performance of contract is impossible, it is void. In other words, impossibility of performance renders the contract void. The section 56 of the Indian Contract Act lays down that an agreement to do an act impossible itself is void. Example, a contract to Example, a contract to construct a building within 2 days. The above element of contract are discussed in detail in the subsequent lectures or chapters, that is offer and acceptance in the lecture 3, consideration in lecture 4, capacity to contract in lecture 5, pre-consent in lecture 6,